Hello and welcome everyone. Thank you for joining us today. My name is Chie Kasahara, the Regional President of Asia Pacific of GALA. I'd like to start this webinar, Emerging Advertising Law Issues in the Asia Pacific region. Before we got started, we have a few housekeeping items. First, this webinar will be recorded and made available for on-demand viewing. Second, please feel free to submit your question at any time during the webinar using the chat function. We will do our best to address as many questions as we can. Thank you again for being here. Without further delay, I will pass the mic over to my colleague Julika. Julika, could you introduce our speakers?
Thank you, Chie. Hi, everyone, and welcome to our webinar today. I'm just going to quickly introduce our speakers that we've got. We've got a range of advertising and IP experts today. They're going to let you know about the emerging interesting issues in their respective jurisdictions. So we're going to start with Peter Lagai from Thomson, Geer in Australia. That'll be followed by Sharad, Vadehra from Khan and Krishme in India, followed by Chie, Kasahara from Atsumi and Sakai in Japan, and I'll finish us off today. I'm Julika Wahlmann-Smith from Hesketh in New Zealand. So I'm going to pass over to Peter to get things underway.
Thank you very much, Julika. Today I'm going to be talking about two key emerging advertising law issues in Australia. The first, one is greenwashing and considers what actions the Australian Consumer Law Regulator, the Australian Competition and Consumer Commission, or ACCC, and the Australian Financial Product and Services Regulator, the Australian Securities and Investment Commission, or ASIC or ASIC, have undertaken in this area. The other is the recent legislative limitations placed on the importation and sale of vapes in Australia and the associated advertising restrictions. So, as far as the term greenwashing is concerned, among other things, the ACCC considers greenwashing, in the context of the examples I will be discussing today, to be claims which misrepresent the environmental impact associated with a business or the goods and services it supplies. On the other hand, as it considers greenwashing in relation to investments to be the practice of misrepresenting the extent to which a financial product or investment strategy is environmentally friendly, sustainable, or ethical. So the first case I'm going to be looking at and the actions undertaken by the ACCC is an action that occurred in November last year in 2023, where the ACCC accepted a court enforceable undertaking from Moo Premium Foods, which produces a yogurt, in relation to false or misleading representations regarding the company's yogurt packaging. Such representations appearing on the packaging itself, as you can see on the screen, on the company's website and on the company's social media pages. The ACCC claimed that Moo Premium Foods contravened the Australian Consumer Law, or ACL, by claiming that their yogurt packaging was made from 100% ocean plastic, which conveyed the impression that the packaging was made from plastic collected from the ocean, when in actual fact the packaging was made from reclaimed ocean-bound plastic, that is, plastic that has been collected from within 50 kilometres of the shoreline from communities that do not have an effective waste management system. Now, the ACCC alleged that Moo Premium Foods contravened the following sections of the ACL. Section 18, which is a broad provision that deals with engaging in conduct that is misleading or deceptive or is likely to mislead or deceive. Section 29(1)(a), in relation to the supply of the yogurt product, made false or misleading representations relating to the composition of the yogurt packaging, and another specific provision under Section 29(1)(g), in relation to the supply of the yogurt product, made false or misleading representations about the environmental benefits of the yogurt packaging. And lastly, another broader section, Section 33, where they alleged that Moo Premium Foods engaged in conduct that was liable to mislead the public as to the nature or manufacturing process of the yogurt packaging. Whilst the packaging contained disclaimers referring to ocean-bound plastic, in smaller font on the top and at the back of the packaging, the ACCC took the view that the dominant message on the packaging was ocean plastic and that the disclaimers were considered to be insufficient to overcome the misleading ocean plastic representation. To resolve the matter, Moo Premium Foods provided the ACCC with a Section 87B undertaking admitting that the ocean plastic claim was misleading and to not make the ocean plastic representation again without proper substantiation, to conduct regular audits in relation to the nature and location of the resins concerning the continued use of the ocean plastic claim, which they still use today. So they're allowed to use ocean-bound plastic as long as it's clear what that relates to. They had to also establish and implement a compliance program, and they had to publish a corrective notice on their website and social media pages for 60 days. The next example is a more recent one, which is, and it's very similar to the Moo Premium Foods matters regarding the use of the term ocean plastic. And this arose in April this year when the ACCC commenced proceedings in the federal court against Clorox Australia, the Australian importer and distributor of the Glad branded kitchen tidy and garbage bags, which I think everybody would be familiar with. As with the Moo Premium Foods matter, the ACCC alleges that Clorox Australia had made false and misleading representations by claiming that its bags were made from 50% ocean plastic, when in fact the plastic was from ocean-bound plastic, again, namely plastic that is collected from within 50 kilometres of the shoreline from communities that do not have a formal waste management system. The difference with this case, and it is unlike the Moo Premium Foods matter, Clorox Australia has not been able to negotiate a court enforceable undertaking, and the fact that the federal court proceedings have commenced means that the ACCC is seeking a financial penalty, and this is not unusual when you're dealing with large multinational organisations involving well-known brands, as the ACCC likes to try and make an example of them. And the best way to do that, as far as the ACCC is concerned, is to commence proceedings. So like the Moo Premium Foods matter, Clorox Australia's packaging contained disclaimers on the back of pack, as you can see there. I don't know if you can read all of that, you probably can't, but anyway, referring to ocean-bound plastic and what that means. But the ACCC is alleging that these disclaimers are ineffective given the dominant ocean plastic claim on front of pack, conveying the impression the plastic was taken from the ocean, including the size and colour of the ocean plastic font, the blue colouring on the backgrounds of the packaging and the product itself, and also the imagery used, including a wave. And you can see there's a little bit of a wave on that slide there. The ACCC has alleged contraventions of the same four provisions of the ACL, namely Section 18, the broad provision, Section 29(1)A, Section 29(1)G, and Section 33. At the moment, the matter is still before the courts, and a case management hearing is currently scheduled for 2 November 2024. Now, you can bet your bottom dollar there'll be a large fine. Exactly how much is unclear at this stage. Moving then on to the actions undertaken by ASIC, which is the financial services regulator. Earlier this year, ASIC commenced federal court proceedings against Mercer Superannuation Australia, alleging that Mercer made false or misleading representations to mislead the public about certain financial services, namely Mercer's 7 sustainable plus investment options that were offered to Mercer's members in contravention of sections 12DB1 and 12DF, which are equivalent provisions of the misleading and deceptive conduct provisions under the Australian Consumer Law, but these are provisions of the Australian Securities and Investment Commissions Act, or the ASIC Act. Essentially, Mercer marketed its investment opportunity options as being suitable for members who are deeply committed to sustainability, as it excluded companies involved in fossil fuels, alcohol production, and gambling. The reality, however, was that the investment options related to companies that were involved in the extraction of fossil fuels, and were involved in the production of alcohol, and were involved in the gambling industry. As a result, on 2 August, the federal court found that Mercer had contravened the ASIC Act as alleged and ordered declarations, payment of a very hefty fine of $11.3 million, publication of a 6-month adverse publicity order, and payment of ASIC's legal costs of $200,000. So an expensive little exercise for them. As noted by Justice Horan in the Mercer case, it is vital that consumers in the financial services industry can have confidence in environmental, social, and governance claims, i.e. ESG claims, made by providers of financial products and services, and any misrepresentations in relation to ESG policies or practices associated with financial products or services, whether as an aspect of greenwashing practices or otherwise, undermines that confidence to the detriment of consumers and the industry generally. And this is a common thread that both ASIC and the ACCC run when they bring these sort of cases. There are currently two other ASIC investment or super fund cases before the federal court regarding misleading representations involving ESG claims. One involves Vanguard Investments Australia. The other one involves a company called Active Super. Now, with the Vanguard Investments matter, they're all the same issues in that they're making claims about sustainable products and services targeted to those people or their members who might be interested in those sort of things, when in fact they're not. So there was a hearing earlier this year that found that Vanguard Investments Australia had engaged in misleading or deceptive conduct, and a financial penalty cost hearing took place on 1 August of this year. We don't know what the result of that is. The judgment's currently reserved, but you can bet your bottom dollar it'll be another very, very hefty $1 million fine. The other case, Active Super, again, same issues arose there. There was a hearing on the 5th of June where Justice O'Callaghan found that Active Super had public representations which were misleading or deceptive, and those representations were on its website, reports and disclosure documents. That matter is currently listed for a financial penalty order and final orders on 17 December of this year. So again, you can expect another very large financial penalty there. So very briefly, what do companies need to do in order to avoid advertising their products as greenwashing? Easiest thing, the ACCC has a published Making Environmental Claims Guide, which covers 8 principles to help businesses with their environmental marketing and advertising claims to ensure they do not mislead consumers. I won't go through each of those 8 principles, but they should be reviewed when a business is considering making a green claim. As far as ASIC is concerned, information sheet 271, ASIC has summarised the main types of conduct that requires ASIC to intervene, such as when a company makes a net zero statement and target without a reasonable basis, or the statement is factually incorrect, use of the terms carbon neutral, clean or green that weren't mentioned on reasonable grounds, and the use of inaccurate labelling or vague terms in sustainably related funds. There's also an inquiry by the Australian Parliament into greenwashing, and that report is expected to be released next month on the 20th of November. I'm sorry, not next month, the month after that, 20th of November of this year. So that'll be an interesting reading. And lastly, obviously, if there's any issues, you should also seek legal advice before making the claims. Now, quickly on to vaping. Vapes in Australia are now considered to be therapeutic goods, and accordingly, the importation, manufacture, sale and advertising of vapes in Australia is strictly regulated. The Department of Health and Aged Care defines vapes as battery-operated devices that deliver an aerosol by heating a liquid that users breathe in. People commonly refer to this aerosol as vapour and to using an e-cigarette as vaping. Various substances can be vaped, including nicotine, nicotine-free liquids made from a mixture of solvents, sweeteners and other chemicals and flavourings, which always made them actually attractive to kids, essentially, because they would be a sweet-tasting vape, and other drugs such as cannabis. Just looking at the Australian vaping landscape as it is now, import controls as of 1 January of this year, the importation of all disposable vapes is being prohibited. So it's a disposable vape, you can't bring it into this country, irrespective of the nicotine content or the therapeutic claims. As of 1 March of this year, therapeutic vapes had to be imported with a licence and a permit from the Office of Drug Control, and specific product requirements were introduced for imported therapeutic vapes, including limiting nicotine content and limiting available flavours, including sort of limiting to menthol, mint or tobacco. So that takes away the interest that the kids may have had as well. So changes from 1 July All these advertising regulations are set out there on the slide, but following the introduction of the Therapeutic Goods and Other Legislation Amendment Vaping Reforms Act of 2024, various changes were made to the access of vaping products. The greatest change introduced was that vapes were no longer available at tobacconists, vape shops and convenience stores, which used to be sold very, very easily, and that the vapes can only now be sold in Australia by pharmacies. So until 1 October this year, a person needs a prescription from a doctor or a nurse practitioner to purchase nicotine vapes from pharmacies. And from 1 October of this year, a person aged 18 or over can purchase a nicotine vape directly from a pharmacy without a prescription. So they're just limiting the access to pharmacies only and for therapeutic purposes only. So just lastly, the restrictions on the advertising and promotion of vapes, the advertising of vapes is now prohibited unless authorised by the Therapeutic Goods, Vaping Goods Advertising Authorisation 2024. Strict conditions exist in relation to the advertising of therapeutic vapes. In addition, in accordance with the Therapeutic Goods Act, a person can receive both criminal and civil penalties if advertising vapes without authorisation or not in accordance with the authorisation. And just to give you an idea of some of the penalties, there's both, as I said, there's both criminal and civil offences. Criminal offence, the penalty for an individual can be up to 7 years imprisonment if you advertise without an authorisation or not in line with the authorisation, or 5,000 penalty units, which works out to be about $1.5 million. There's also a strict liability offence, and for the civil penalties, basically the same situation applies in relation to advertising without an authorisation or not in line with the authorisation, except the fines are very, very significant for an individual, up to a maximum of almost $2.2 million, and for a company, almost $22 million. And I think that's all I have to say, and I'll pass you on now to Sharad.
Peter, good morning from India. It's early in the morning, and one of the biggest countries in the world in terms of population. Now, I'm going to share with you developments that are happening in India. Huge consumer base, a lot of advertising issues. We actually have two bodies out here, which I'm going to cover in the presentation today. The Advertising Standards Council of India, which is making guidelines for advertisements relating to environmental and clean laws. And then there is the CCPA, which is the Central Consumer Protection Authority, which protects all consumers. So there will be some overlap in what the ASCI has made and what the CCPA is promoting, or in fact, suggesting in this draft guidelines. So the green claim suggesting that a product and or its packaging or a service as a whole has a neutral or positive impact on the environment is comparatively less damaging to the environment than the previous version, is less damaging to the environment than competing goods or services, or less environmental benefits. If the moment these assertions are made, you have to substantiate it with a lot of data, a lot of evidence. Absolute claims such as environmentally friendly, eco-friendly, sustainable, planet-friendly must be capable of substantiated by robust data and or well-recognized and credible accreditation. Comparative claims such as greener, friendlier, need supporting evidence and basis of comparison. These are all guidelines which have been laid down and are to be strictly followed, and this is already the practice that is being followed in India. Environmental claims must be based on full life cycle unless otherwise stated. So you just, any advertiser, any promoter of a particular product could not say that those environmental friendly claims which it asserts are safe for a particular year or 2 years. It has to be for the full life cycle of the product. Environmental claims have to specify whether it refers to the product, the product packaging, a service, or just to a portion of that product. The absence of an environmentally damaging ingredient is not permitted. This is very important. It is not permitted if you just highlight the fact that there is an environmentally damaging product which is absent, provided that ingredient is not usually found in competing products as or services. So what is present or what is absent in the competing products have also to be kept in mind when you promote a particular product in India as not having an environmentally damaging ingredient. If certifications or seals suggest environmental claims, the advertiser must clarify which product or service attributes were assessed by the certifier. This is important, and this is being checked by all advertisers and the authorities here back in India. Going to the next slide. Yeah. No, you refrain from making aspirational claims. So something that is about future environmental objectives, unless you have a clear and actionable plan, refrain from making aspirational claims. Advertisers must clearly disclose if carbon offsets won't occur within the 2 years. This is important because you cannot make such disclosures arbitrarily unless such carbon offsets are going to occur within 2 years. The words which have to be defined with scientific evidence, such as compostable, biodegradable, recyclable, non-toxic, free of. These claims have to define or specify the scope and have to be well supported by scientific evidence. Now comes the CCPA draft guidelines. I emphasize on the word draft because these are still in the draft form, and you will notice there's a lot of overlap between the Advertising Standard Council of India guidelines, which is a self-regulated body in India, and the CCPA guidelines. There will be a lot of overlap. Now, what kind of products or services are prohibited in advertising in greenwashing, which includes any deceptive or misleading practice, such as concealing, omitting, or hiding relevant information by exaggerating, making vague, false, or unsubstantiated environmental claims, the use of misleading words, symbols, imagery, placing emphasis on positive environmental aspects while downplaying or concealing harmful attributes. Now, this is something which is prohibited. Substantiation of environmental claims. Here comes the overlap with the ASTI guidelines. Generic terms such as clean, green, eco-friendly, eco-consciousness, good for the planet, minimal impact, cruelty-free, carbon neutral are not to be used without adequate qualifiers and substantiation. So this really strengthens the hands of the authorities to clear up the advertisements, provided you have adequate qualifiers and certificates for substantiation, meaning or implementation of technical terms like environmental impact assessment, EIA, greenhouse gas emissions, ecological footprint. These all have to be clarified. Environmental claims have to be supported by verifiable evidence. We already covered that. Adequate disclosures have to be made, including accurate and all material information. Highlighting only favorable observations is not permissible. So you highlight only the favorable observations without going into the details of what could also be unfavorable. That is not permissible. Specify the scope of the claims. Comparative environmental claims must be verifiable, and the scope of the comparison has to be disclosed. Again, there is an overlap here, specifying environmental claims such as carbon offsets, carbon neutral, compostable, degradable, free of sustainability claims, non-toxic, 100% natural, ozone free. They all have to be verifiable independently by a third party. Now, the CCPA has come up. The CCPA, again, I repeat, is the Central Consumer Protection Authority in India. They have come up with an advisory on prohibition of ads on unlawful activities. The CCPA issued an advisory dated March 6, 2024 on the prohibition of advertising, promotion, and endorsement of unlawful activities prohibited under various laws. Online gambling is one of such examples. Online gambling and betting is unlawful in its status in majority of the 28 odd states in India. which renders one equally liable for participating in an illegal activity. Or they encompass celebrities, influencers. They all have to refrain from endorsing and promoting illegal betting and gambling activities. So it's not only the organizers who are held as responsible, but also celebrities and influencers are held responsible. In case of violation, stringent measures under the Consumer Protection Act 2019 shall be initiated against the entire spectrum encompassing, now this is important and very, very well taken by the industry. It encompasses manufacturers, advertisers, publishers, intermediaries, social media, platforms, celebrities, influencers, endorsers, and all other relevant stakeholders. So encompasses all bodies, all stakeholders associated with the particular advertisement. We had a very interesting case in India, and initially being a common law country, an applicant or a person who wants to file a complaint can file a writ petition. So a writ petition was filed against an Indian company called Patanjali Ayurved for publishing misleading advertisements with claims of curing diseases with Ayurvedic products and disparaging allopathy, especially during the COVID pandemic. The Honorable Supreme Court, so this matter went up to the Supreme Court, and the Supreme Court of India, by this order dated May 7, 2024, held that advertisers, advertising agencies, endorsers are equally responsible for issuing false and misleading advertisements. So it held not only the promoter of the person who brought the product or made the ad as a company, but also the advertisers and the advertising agencies and endorsers equally responsible. So mandatory submission of self-declaration certificate. For the first time in the history of India, a self-declaration certificate was required as per the orders of the Supreme Court regarding any compliance of relevant laws and regulations before publishing of or broadcasting any ad. It says publishing or broadcasting of any ad. So this is a very broad spectrum, and it covers all media, all particular channels, even through paper, through television, through social media. It encompasses all such particular mediums of information transmission. We then had the Food Safety and Securities Body of India, Association of India. They would take suo motu cognizance of misleading advertisements without waiting for any complaint to be received. So in such situations, FSSAI will take suo motu action without waiting for a complaint to be lodged in these matters. The Ministry of Information and Broadcasting. So when things get going in India, they go full gear, they go full throttle. So now the Ministry of Information and Broadcasting of India also comes into picture. They issued a notification on the 3rd of June, 2024. And the notification said all advertisers, advertising agencies must submit a self-declaration certificate before publishing or broadcasting any advertisement. So that self-declaration certificate has to be produced or published before broadcasting any ad. The self-declaration certificate is required for all new ads that will be issued, telecast. This is important for you to see. Will be issued, telecast, aired, published on or after the 18th of June 2024. The self-declaration certificate is to certify about the advertisement, and it can be uploaded on the website, which I have given here and below in the slide. Thereafter, there was a massive uproar from the industry because these requirements were too stringent, too strong for companies, for advertisers to comply with, not only Indian but foreign companies. We received so many grievances from overseas and from India that these requirements were very stringent. Following this uproar, the Internet and Mobile Association of India, IAMAI, the Indian Newspaper Association, INS, And the Indian Society of Advertisers, ISA, requested the Ministry of Information and Broadcasting to reconsider the mandate as it requires more consideration and resolution before implementation. The MIB took cognizance of such complaints and issued a new advisory dated 3rd July 2024, which supersedes previous advisories on self-declaration certificate requirements. The advertising agencies issuing ads for products and services related to food and health sectors. Now, what has resulted is they have restricted such self-declaration only to the ads related to food and health sectors, and they have to upload an annual certificate, annual self-declaration certificate. So not do it every time an ad has been published or is going to be published, but it has to be done on an annual basis. And for TV or radio advertisements, it's on a particular website. For media or internet, it's also on a particular website. It has been given in the slide here and below. And following this, there has been the advertising agencies have also to make available the proof of uploading the self-declaration to the concerned media, sweeps stakeholders such as TV channels. So you have to give adequate evidence of uploading that self-declaration notice. It is also responsibility of the advertisers, the advertising agencies to ensure that every ad being issued by them is in adherence to applicable Indian laws, rules, and regulations in letter and spirit. This resulted in a collaboration between the self-regulation body in India, the Advertising Standard Council of India, and the CCPA. The ASI Code of Advertising Guidelines align closely with the guidelines of CCPA. The CCPA, which is still drafting its guidelines, has now asked the self-regulating body in India, ASCI, to forward any ad that is non-compliant with the ASCI code and is in potential violation of the Consumer Protection Act 2019. Any such ad forwarded by ASCI will be promptly addressed and handled by the CCPA. I now hand over the next slides to be given by my colleague from Japan, Chie Kasahara.
Thank you, Sharad. I would like to speak on two topics for Japan: stealth marketing and use of AI in advertising. First, stealth marketing was not prohibited in Japan and was frequently used. However, this was problematic as consumers could be misled to believe that an influencer or the post is genuinely giving a high evaluation of the product or service, hiding the fact that it is an advertisement. Some voluntary guidelines sought to address these issues and recommended advertisers to add or sponsored relevant material in order to clarify the purpose is advertising, but this was not legally required. I have two examples criticized as stealth marketing. This kind of post was made by influencers at the request of the distributor. Influencers were instructed to post the comments under the guise to being a product monitor in exchange for free products. This is a supplement advertised for breast enhancement, improvement in intestine health, and skin issues. The advertiser asked influencers to post on social media without disclosing their relationship with the advertiser and a distributor. This supplement was subject to cease and desist order by the Consumer Affairs Agency as it was considered a misleading representation prohibited under the Act Against Unjustifiable Premium and Misleading Representations as a misleading representation of superiority. On the other hand, It has been pointed out that under the Act Against Unjustifiable Premiums and Misleading Representations, stealth marketing cannot be regulated if there is no misleading representation of superiority or advantage in the displayed contents. An apology posted on Disney's website after several cartoonists or illustrators' SNS posts about Frozen Second, which were criticized as stealth marketing. Even if it does not illegal, excessive stealth marketing often provoked consumer backlash and criticism. This was the case when Disney faced criticism for having multiple illustrators and others post their positive review of the movie Frozen Second on social media on its release, leading them to post an apology message on the web. To address these issues, in March 2023, the Cabinet Office issued a notification which designated stealth marketing as a misrepresentation under the Article 5, Item 3 of the Act Against Unjustifiable Premiums and Misleading Representation. The notification applies to advertisement that the public may not recognize as advertisement and which are made in type of media or all type of media and by business that supply goods and services. Third parties such as influencers who receive requests from companies to advertise or promote their products and services and advertising company are not included in the scope of such businesses. If a result of an investigation by the Consumer Affairs Agency, a business is found to have violated the notification, the agency can issue a cease and desist order against the business, ordering the business to discontinue the statement, inform the public of the violation, take measures to prevent the violation occurring again, not repeat the violation in the future. A person who violates such an order shall be liable to imprisonment for up to 2 years and/or a fine of up to 3 million yen. I'd like to move to the second topic, the use of AI in advertising. Japan's Copyright Act is tolerant toward AI learning, allowing the use of others' copyrighted work for AI training without permission. Due to cultural influence from characters like Astro Boy and Doraemon, it is said that Japanese people are generally more accepting of the use of AI in advertising. Looking at this slide, this AI talent is an exclusive original talent generated by AI technology and uses services provided by an AI model, which optimize the branding and promotion of the major beverage company. According to the company, the AI talent appears in the TV commercial is a persona that everyone, regardless of gender, will find healthy, active, progressive, strong-willed. And the designer and creators selected a number of AI-generated face output and fine-tuned the talent image to that end. This commercial effectively used AI talent to convey that one must pay attention to their health now by comparing oneself with their future self. And then commercial is perceived by consumers as giving a favorable view of the product in question. AI talent are not always considered favorable in all cases. Depending on how they are used, they can be criticism. For example, this advertisement from August 2024 on X for a discount campaign on McDonald's French fries received significant backlash from consumers and was covered by various media outlets. It was reportedly produced by the AI creator Kakdrop. This promotion video clearly indicates it was generated by AI and the creator's name was also specified. And formally, it appears to meet the practical requirement for the use of AI. However, the video was criticized as the food does not look appetizing and the characters appear unnatural, especially the number of fingers for a character seemed to be incorrect. There is no regulation on the use of AI for advertising in Japan. But I would like to recommend in practice to clearly indicate the use of AI, confirm whether the expression used are appropriate for the product or service being advertised, confirm whether the image generated by AI infringe on anyone's portrait right or copyright, confirm whether there are any expressions that might be offensive to the target audience. In Japan, while AI learning is widely accepted, care must be taken because if AI-generated work infringe on someone's portrait right or copyright, they could constitute a tort or copyright infringement. I have explained two recent topics in Japan. I hope my talk could be helpful to everyone. Thank you very much. I would like to take over Julika.
Okay. Great. So today I'm going to finish us off by talking about a few areas that have been emerging this year in New Zealand, starting with a few advertising standards codes that have been reviewed, being the Children's Advertising Code and the Food and Beverage Advertising Code. Then I'm going to talk briefly about biometrics, including some Privacy Act considerations and a new code that is being proposed in this area. And then I'm going to finish off on just one recent case to show what our regulator's been looking at recently. So to start with our Advertising Standards Authorities Codes reviews, our ASA is effectively a self-regulatory body here in New Zealand that regulates advertising. As part of that, create a variety of codes, including one general overarching advertising standards code and 6 specialty codes. Every 5 years, they undertake a review of each code to make sure they are still fit for purpose in the current environment. And in 2022, the ASA launched a review of the Children and Young People's Advertising Code. What followed was quite a long process of public consultation, which ended up deciding that, in fact, it was more appropriate to have 2 new codes as opposed to the 1 remaining code. And so we have now got a new Children Advertising Code and a separate Food and Beverage Advertising Code. The new codes have been effective for new advertisements from 1 August this year and will apply to all existing advertisements from 1 November this year. So having a look at the Children Advertising Code, this code applies to any advertising that is targeted at children, either through content or placement. If an advertisement is considered to be targeted at children, will be determined by reviewing a variety of factors. This includes the nature and intended purpose of the product, the brand, or the messaging, and if it's considered to be appealing or popular by children. The advertisement's content, in particular if the content appeals to children, including using themes like the use of cartoons or having children as a key feature of the ad or key sort of talent as part of the advertisement. It also looks at the expected age of the audience. So to the extent that the audience of the advertisement is expected to be 25% or more children, then it's likely that the ad could be considered to be targeted at children, considering it in the context of a variety of these other factors we're going through. Other things that I'll look at is tools that are used to target children. So that'll be things like where the advertisement is placed, the topic, keywords that are used. If you are using influencers, if the influencer is under 16, they will be more likely to be considered to be targeting at children. And if they are over 16, but their followers are 25% or more children, then again, they're more likely to be considered to be targeted at children. And again, looking at the placement of an advertisement, you're looking at the time that it's broadcast, if it's in between children's programs, for example, or the location of physical advertisements. So if it was within 300 meters of a school is another example. So there's quite an extensive list of factors to consider to see whether your advertisement might be caught by this code or not. We have seen that complainants will raise things very quickly to consider that something is targeted at children, even when it might not be the intention at all. For example, we have seen where children are used in vehicle advertisements for complainants to consider that these are targeted at children. But so far, our ASA has taken a relatively common sense approach in those scenarios and declined the complaint on those specific bases. But it is something to be very conscious of if you're using children in your advertisements or targeting it at them. So the two main focuses of the code is social responsibility, ensuring that advertisements targeted at children are prepared with a high standard of social responsibility and not contain anything that could result in children's physical, mental, or moral harm. Also, truthful presentation is very important, making sure that the ads are truthful, balanced, and not misleading. The new code is relatively similar to the previous code that we had, but there are a few key changes, and this includes the age of children. Children are now defined as individuals who are under the age of 16. This is a move away from the previous code, which looked at children being under 14, but had a separate category for young people. So now it's just across the line, children being considered anyone under 16. As we've just gone through, there is new extensive targeting criteria to be considered. The next point is safety. So we've got a few more detailed guidance in relation to safety, making sure that advertisements that are targeted at children do not condone unsafe practices. For example, children must not be shown near or using dangerous substances such as medications or equipment, such as electrical appliances, without direct adult supervision. There are also enhanced disclosure requirements. So this is really aimed at making sure that children are aware that they are interacting with advertisements. So just making sure those requirements to identify your advertisements are even clearer when you are dealing with children to whom it might not be obvious that content is an advertisement. There's also a restriction on fear and distress, making sure that there's no unjustified use of fear or distress in advertisements that target children. There's also some guidelines in respect of apps and video game advertising. Again, making sure that it is very clear to children that in-app purchases, for example, are in real currency and not just part of the game. The other separate code that we have is the food and beverage advertising code. So this applies to all food and beverage advertising, not only advertising focused at children, but across the board. Again, the two key principles of this code are social responsibility, being that all ads are advertise food and beverage with a high standard of social responsibility to consumers and society, and truthful presentation, so that food and beverage advertising must not mislead and be truthful and balanced. Few key features that come through is health and well-being, which is always a big hot topic, making sure that there is no, I suppose, unnecessary encouragement of unhealthy habits. So advertising food and beverages must not undermine health and well-being of individuals. Excessive consumption should be restricted and not portrayed. Occasional foods, there is now a special nutrient profiling scoring criteria to determine whether a food is occasional or not, as there are specific restrictions in relation to occasional foods, in particular that you cannot target occasional food at children. There are also restrictions in relation to brand advertisements and sponsorship advertisements. So here, if an occasional food brand is sponsoring, let's say, a sports team, if it is targeted at children, they cannot show the actual occasional food product, and they need to focus on the sponsored team in this example. So there's just some real restrictions there depending on the type of product that's being used as part of the sponsorship, to make clear that you're not in breach of these rules. Biometrics is another area where we've seen a real increase of awareness and interest in New Zealand recently. One example of this coming up, as a topic, is these smart screens that are installed in shopping centres. These digital billboards are effectively equipped with AI facial detection technology and are used to sort of analyse the passers-by to be able to target the most appropriate advertisements to them. And we have seen our Consumer New Zealand investigate this topic, and in conjunction with the Privacy Commissioner as well, really looking at whether there is privacy rights that are being infringed when these billboards are collecting data. This is sort of an ongoing area of interest, and it'll be interesting to see where the regulation in this area goes. We do have some existing protections in our Privacy Act, which relates to the collection of personal information in New Zealand, but not all areas of biometric collections are dealt with completely by that act. And so at the moment, what we've got is a proposal of a new biometric processing code. And this, there was a exposure draft of the code that was released this year, and it's intended to govern the use of biometric information and biometric processing in New Zealand. The code has set out 13 rules that must be complied with in relation to undertaking such processing and collecting this type of information. Public consultation is recently closed, and we are awaiting further steps to see how the matter progresses. It is an interesting balance, of course, between the widespread use of biometric information, but just managing privacy concerns there as well. So it will be an interesting area to watch, and we're expecting more developments to come. And one recent case that we've had in New Zealand, which was taken by our Commerce Commission, which is the regulator here who enforces our Fair Trading Act, which is the main piece of legislation that looks at requirements that also apply to advertisements, such as prohibiting misleading or deceptive conduct. This particular exercise involved various advertising and branding in respect of a product that was promoting itself as originating from New Zealand. It also had a fern mark, so it is possible in New Zealand to obtain the license to use a fern mark, which is used to designate your products as being made in New Zealand. And it's a real important part, I suppose, of Brand New Zealand, and it's strictly protected. There's strict licensing requirements. You need to be able to show that your products are made using New Zealand ingredients, for example, before you can use the fern mark. And you're required to, on a continuous basis, confirm that that's in fact still the case. What we had in this scenario is that while initially New Zealand products were being used in the manufacture of the products at issue, that changed partway through, and they ended up using imported products as in a combination with New Zealand products. But that meant that their use of the fern mark and use of all their representations in relation to being made in New Zealand were considered to be misleading, and the Commerce Commission took proceedings, and in fact the Midco Foods Limited actually pleaded guilty to 11 charges under Section 13J and 13F of the Fair Trading Act, and they ended up with a fine of $420,000. What we are seeing in New Zealand, not quite yet at the level that we're seeing in Australia, but we are seeing an increase in fines for breach of our Fair Trading Act. And we're seeing the regulator take a relatively active view and really looking for what advertisements are being put in the market. And there are particular areas of focus, including Brand New Zealand, which, you know, sees an important aspect to the New Zealand market, and making sure that's protected. And so any misleading claims around that, they normally do try and clamp down on. And there's always an ongoing emphasis on substantiations of claims too, which we continue to see. So that was a very quick wrap up for New Zealand. We hope you have enjoyed the seminar today. In case you haven't already had a look at these, GALA's got some excellent resources available on their website. It's also a great idea to sign up to the GALA blog so you can keep up to date with advertising issues across the globe. Doesn't appear to be any questions today, so thank you everybody for your time. If you've got any questions after, feel free to get in contact with any of the speakers or with GALA, and we'll try and help you out. Thank you very much, everybody.